Good afternoon. My name is Palomar Sanchez, and I'm one of the staff attorneys for the City of Richmond Rent Program. Welcome to today's presentation, which I hope you'll find informative, which is the rights and responsibilities for Richmond landlords and tenants. Some of the topics covered today are going to be the purpose of the Richmond Rent Ordinance, the properties covered under the Richmond Rent Ordinance, enrollment, registration, and the residential rental housing fee, excuse me, and the just cause for eviction and eviction noticing requirements, the maximum allowable rent, otherwise known as the MAR, and annual general adjustments, otherwise known as AGAs, and rent adjustment petitions. And then finally, a brief overview of important California law. Now, before I get started, I wanted to briefly mention or remind the public that on March 23rd, 2021, the Richmond City Council adopted an urgency ordinance number 02-21, otherwise known as an eviction moratorium, establishing a temporary moratorium on certain evictions of residential tenants in Richmond, such as owner move-in or breach of lease, through the, quote, local emergency and 60 days thereafter. For more information about this law or to view the City of Richmond's urgency ordinance, please visit our website. The purpose of the Richmond Rent Ordinance. The purpose of the Richmond Fair Rent, Just Cause for Eviction and Homeowner Protection Ordinance, also known as the Rent Ordinance, is to promote neighborhood and community stability, healthy housing, and affordability for renters in the City of Richmond by controlling excessive rent increases and arbitrary evictions to the greatest extent allowable under California law, while ensuring landlords a fair return. This is an overview of the Richmond Rent Ordinance. Essentially, there are two main pillars. The first one is rent control. And essentially what that means is that rents are regulated. The maximum allowable rent, otherwise known as the MAR, is calculated by taking the base rent and then adding annual general adjustments, otherwise known as cost of living increases, plus any allowable individual rent adjustments that is ordered by a hearing examiner. The annual general adjustment is 100% of the consumer price index of the Bay Area, or inflation rate. And then the base rent is the rent that is in effect as of July 21st, 2015, or the first rent charged for the tenant that moved in after that date. And then there's the petition process, which is a mechanism to increase or decrease the MAR based on the reasons permitted by the rent ordinance. Now we move on to the just cause for eviction protection, which essentially means that a landlord needs to have one of the 8 just causes to terminate a tenancy. The first just cause is for failure to pay rent. The second is for breach of lease. Third is nuisance. Fourth is failure to give access when they have a lawful right to do so. Fifth is to temporarily vacate the tenants in order to undertake substantial repairs. But reminder that that's a temporary eviction and the tenants have to be allowed to return to the unit. Owner move-in or owner's relative move-in, withdrawal from the rental market, otherwise known as the Ellis Act, and a temporary tenancy for single-family homes. And just an important note that, and we'll discuss this in a bit as well, but just causes number 5 through 7 require a relocation payment be made to the tenant. All right, which properties are covered by the rent ordinance? So the first one is fully covered or controlled rental units. Those have both rent control and just cause for eviction protection. This includes most multi-unit properties built on or before February 1st, 1995. The second category is partially covered units, which means that they only have just cause for eviction protection, but there is no rent control. This includes subsidized units, including Section 8 tenancies, properties with one dwelling unit on one parcel, such as single-family homes, condominiums, or new construction, which is constructed constructed after February 1st, 1995. And the final category are fully exempt units, where there is no rent control and no just cause for eviction protection. Some of these examples are a landlord where a landlord and a tenant share a kitchen and or a bath, single family homes where a permitted ADU is added and the main house is owner occupied, and retirement homes. There is also categories of accessory dwelling units. This is a chart to help the public understand how an accessory dwelling unit would affect either or both of the when there's a main house and an ADU is added. So as you can see, it depends on who lives in the main house. O is for the owner living in the house. T is for the tenant. That's the larger house there. And then the smaller box is the ADU. If you see a dotted line, that means that the ADU is unpermitted. If the line is solid for the ADU, then it is a permitted unit. So for example, on the first line, if the owner lives in the main house and there's a tenant who lives in the ADU, but it is a permitted ADU, then the ADU is exempt from both rent control and just cause protection. However, the analysis changes whether if that ADU is unpermitted. So if the main house is the owner's primary residence and the second unit, the ADU, is not permitted, then the second unit is under both rent control and just cause. If both units are tenant occupied and the second unit is a permitted ADU, then the main house is under rent control and just cause, but the ADU is under just cause only, so there's no rent control. If both units are tenant occupied and the second unit is not permitted, then both units are fully rent controlled and have just cause protection. If the main house is tenant occupied and the second unit is owner occupied, then the main house is under rent control and just cause. And as you can see, under no situation is the owner's unit ever under rent control. Now we're going to talk about compliance with enrollment, registration, and fee payment requirements. The first is just the property enrollment requirements, which is required for all rental units covered by the Rent Ordinance. So this is just an example of what the form would look like. And essentially, it is just there to show you that that form is specifically for the landlord or property owner's information, also any agents of the owner or property managers. And that form can be found at the website at the bottom of the page. Tenancy registration requirements is only required, so this form is only required for fully covered units, so those that fall under rent control. And again, this is just an example, but basically this form is for the tenancy information, so the tenant's information, not the landlord's. So you enter the address and some basic information, names, the initial rent, how many tenants are there, how many bedrooms, all that kind of stuff. And that form can be found at the website at the bottom of the screen. The importance of enrollment and tenancy registration. So these are just some points as to why we ask this of landlords and tenants, or landlords specifically. First of all, it increases compliance. Submitting information about rent and housing services improves compliance with the rent ordinance by making lawful rent levels transparent to both landlord and tenant. Registration is required for each new tenancy or upon turnover of all original occupants. Second, it supports the rent adjustment petition process. Oops. Tenancy registration provides the hearing examiner with data on lawful maximum allowable rent levels for units under construction, under consideration for rent adjustments. It provides the base year rent data for rent controlled units. It bolsters outreach opportunities. In the near future, tenants and landlords will receive an annual notice of maximum allowable rents and a guide to rent control in Richmond, informing them of vital information about their rights and responsibilities. It improves the fee study and billing accuracy. Enrollment improves the accuracy of the rent program's inventory of rent units and its annual fee study. Landlords are required to enroll rent units and update status of rental property. For example, if a rental unit, if a unit is now owner occupied, or if a Section 8 tenant moves out and a rent control tenant moves in. And then the final, the final of this page is that compliance is required for rent increases or eviction. Another important reason for enrolling, registering tenancies, and paying the rental housing fee is that failure to substantially comply with the applicable sections of the rent ordinance may prevent the landlord from raising rent, e.g. taking AGAs, and may be an affirmative defense to an eviction lawsuit. The residential rental housing fee. The rent ordinance requires the city council to adopt a residential rental housing fee following a recommendation from the rent board. So here you can see examples of the previous fiscal year's charges per unit. And so there are governmentally subsidized unit initially, partially covered units, and fully covered units. Now we have just partially covered or fully covered units. So this last fiscal year for 2021-2022, the fee for fully covered rental units was $218 per unit per year. And then the fee for partially covered rental units was $123 per unit per year. Okay, so now we're going to talk about the compliance with the just cause for eviction requirements, which is just cause for eviction, what those are, and then the eviction notice and requirement. Just cause for eviction. So residential tenants can only be evicted for one of the following just causes under the Richmond Rent Ordinance. Again, this has to be caveated with the current urgency ordinance that was mentioned earlier at the beginning of the presentation. But these are the 8 just causes. So again, failure to pay rent after having served a 3-day notice to pay or quit. Breach of lease, if a tenant continues to violate the lease after being warned in writing to cease the violation. Nuisance, if a tenant continues to cause a nuisance after being warned in writing to cease causing the nuisance. Failure to give access, if a tenant continues to deny a landlord or their agent lawful entry per Civil Code 1954 after receiving a written warning to cease denying lawful entry. To temporarily vacate the tenants in order to undertake substantial repairs. Owner move-in, withdrawal from the rental market, otherwise known as the Ellis Act, and temporary tenancy. And as you can see from the stars that are associated with the last, besides the very last one, the final 3 just causes, a relocation payment is required for those evictions pursuant to the City of Richmond's relocation ordinance. Okay, the written warning notice requirements as required under the Richmond Municipal Code and the Rent Ordinance. So these must be served prior to a notice of termination of tenancy if the just cause for eviction is either breach of lease, nuisance, or failure to give access. It must provide the tenant with a quote unquote reasonable period of no less than 5 days to correct the violation prior to serving a notice to terminate tenancy. It must state that the failure to cure may result in an eviction. It must inform the tenant of their right to request a reasonable accommodation. It shall include the contact number of the rent program, shall include instructions for compliance, and shall include information necessary to determine the date, time, place, witnesses present, and other circumstances regarding the alleged violation. And we actually have a warning notice template which can be found available at the address at the bottom of the screen. So under Regulation 1001, landlords must submit a copy of any termination of tenancy notice served on a tenant within 2 business days of serving the tenant, along with a proof of service. The termination of tenancy notice should be submitted online at that website that's on the screen. And for properties with 5 or fewer units, the landlord may submit the notice by mail. The rent program does not accept notices of termination by email. Failure to file the termination of tenancy notice timely may be asserted by the tenant as an affirmative defense in an unlawful detainer, otherwise known as an eviction proceeding. And by the way, these noticing rules are only applicable for units that are covered by the just cause for eviction sections of the ordinance. Okay, compliance with the rent control requirements. So this is talking about the maximum allowable rent, the base rent, the annual general adjustment, and rent increase noticing requirements. First is the maximum allowable rent, otherwise known as the MAR. This is the maximum rent that can be charged for a controlled rental unit. A rent increase cannot exceed the maximum allowable rent, but it can be less. Even if the maximum rent is not charged, the maximum allowable rent remains the same. The landlord may choose to raise the rent to the maximum in accordance with, I should say state law, not stale law, and the rent board's banking regulation. So the maximum allowable rent actually equals the base rent plus any annual general adjustments that haven't been applied. And then any individual rent adjustments approved through the petition process. So again, the maximum allowable rent is the base rent plus all the annual general adjustments plus any individual rent adjustments that have been approved through the petition process. The annual general adjustment. So what is the AGA and how is it calculated? It's an annual allowable cost of living increase based on 100% of the consumer price index of, I believe is the San Francisco Bay Area. When can the first AGA be taken after a new tenancy starts? 1 full calendar year must expire after September 1 of each year. So meaning if you started, for example, in July of 2022, you would not be able to take that year's AGA in the same year because a year hasn't passed from July to September. But you could take the 2023 AGA because from July 2022 to July 2023, and then September 1 of 2023, that would be your first AGA. When during the year can the AGA be taken? Generally, the AGA can be taken on September 1st of each year after proper legal notice. Can landlords, quote unquote, bank AGA increases? Yes, but there is a limit of 5% of previously deferred AGAs, which can be recovered each year, plus the current year's AGA. But rent increases may not be applied retroactively. For more information on banking, see Regulation 602. So again, if you have multiple years of AGAs and you want to catch up, you have to first add 5% to the current year's AGA. So say, for example, right now, the current AGA is 1.6%. You add 5% to that, that's about 6.6%. That means that of all your AGAs that you have not added up yet, so long as they are at or less than 6.6%, you can add them up and apply them with a properly noticed rent increase. But if they go beyond 6.6%, then you would have to wait till the following calendar year. Here is a list of the annual general adjustments from 2016 to 2021. So in 2016, it was 3%. 2017, it was 3.4%. 2018, it was 3.6%. 2019, it was 3.5%. In 2020, it was 2.9%. And in 2021 is 1.6%. And the note at the bottom is just a reminder that a landlord must give the tenant proper notice of a rent increase per California Civil Code 827. A landlord may increase the rent up to the maximum allowable rent with a 30-day written notice, so long as that increase is 10% or less. So what are the requirements for taking an AGA rent increase? Well, first, there are the administrative requirements, and then there are the noticing requirements. So the administrative requirement just simply means that a landlord must be in compliance with all aspects of the rent ordinance, including property enrollment, tenancy registration, paying the rental housing fee, and properly rolling back rent and refunding any overcharges to tenants. In terms of noticing requirements, they must provide the rent program with a copy of the rent increase notice with a proof of service within 10 business days of having served the tenant. And as a reminder, only properties that are subject to the rent control provisions of the ordinance are required to file rent increase notices with the program. So if you're wondering that if you have a single family home, whether or not you have to file these rent increase notices, the answer is no, you do not. When rents can be raised to market? So this is a common question, and these are some examples. First of all, when there is a voluntary vacancy and a new tenancy starts, that is your opportunity to set the rent to quote unquote market. Second is when all the original occupants or leaseholders vacate and only holdover subtenants or tenants remain in the unit. So if you have a rollover of tenants and eventually all the original people who first rented the unit are gone, that counts for you to reset the rent for the entire unit to market. And the final reason is if the tenant no longer lives in the unit as his or her primary resident, i.e. the leaseholding tenant is subletting or using the unit as a vacation home. They have to be there as their primary residence in order to enjoy rent control. Rent adjustment petition. So first is tenant rent adjustment petition. So these are some examples. So there's a petition for excessive rent due to failure on behalf of the landlord to roll back the rent or for charging rent above the maximum allowable rent. Very common, probably one of the more common tenant rent adjustment petitions. The petition to reduce rent due to a decrease in space, services, and or habitability, or the violations of applicable codes. This is probably also very common, probably the second most common. Petition to reduce the rent due to a reduction in the number of tenants allowed. So if a landlord tells a tenant that they started off with 4 people and one of them leaves and said you can't have any replacement tenants, then those tenants can actually file a petition to reduce the rent by the percentage that the landlord prohibited them from getting back to their full tenancy. So in that example, you originally start with 4, one person leaves, landlord says, I only want you 3 to stay. Those tenants could file a petition to reduce the rent by 25% because that's a 25% reduction in the amount of tenants. Important petition facts. Landlord has a right to object to the petition always. Most petitions and almost all habitability petitions will result in a hearing conducted by a hearing examiner. Some petitions will be decided administratively if no objection is filed by the other party and the facts of the case are straightforward or not disputed. And finally, either party can appeal a hearing examiner's decision. All right, so these are the landlord rent adjustment petitions. The first is a petition to increase the maximum allowable rent due to the increase in number of occupants allowed. And as you can see, there's a star there says a petition for an increase in the number of occupants will not be approved if it concerns additional tenants pursuant to the regulations of the Richmond Rent Board, Section 903B2. We can, if you have questions about that, you can contact our office. Petition to increase the maximum allowable rent due to an increase in space or services. A petition to increase the maximum allowable rent due to increases in net operating and maintenance costs. That's probably the most common landlord petition. And finally, a petition to increase the maximum allowable rent due to increases in security deposits due to the addition of pets. And in some important petition facts, tenants always have the right to object to a petition, just like landlords do. Most petitions and almost all habitability petitions will result in a hearing conducted by a hearing examiner. Some petitions will be decided administratively if no objection is filed by the other party and the facts of the case are straightforward or not disputed, and either party can appeal a hearing examiner's decision. Okay, finally, we're going to talk about we're going to overview some important California law. So first is the implied warranty of habitability and the implied covenant of quiet enjoyment. The implied warranty of habitability is a legal theory which has been developed and defined through various court cases. The California Supreme Court has expressly held that the implied warranty of habitability exists in all residential rental agreements. And there's a specific court citation there that you can look up. This means that it is the landlord's duty and promise to provide tenants with safe and sanitary housing as defined in Civil Code 1941.1 and Health and Safety Code 17920.3 in exchange for collecting rent. Similarly, implied in every California residential lease is an implied covenant of quiet enjoyment, guaranteeing that tenants will be able to peacefully enjoy their homes. This is also under California Civil Code 1927. This quiet possession includes two requirements. First, that the landlord may not take an action that substantially interferes with the tenant's lawful use of their home. Second, the landlord must take action to provide a tenant with the quiet enjoyment or quiet possession of the tenant's home if the landlord is aware that the tenant's lawful use of the property is jeopardized. Obviously, that is all within what the landlord can actually do. Sometimes it's out of their power, but if it isn't within their power, they have to take action. Okay, Civil Code 1941.1. Again, landlords must provide a property that is in a habitable condition and fit to live in. Landlords must repair problems and make the property uninhabitable, except for problems caused by the tenant or their guests, children, or pets. For the property to be habitable, you must have all of the following. And so there's a long list of this civil code, but it essentially talks about waterproofing, weather protection, gas facilities, heating facilities, plumbing facilities. Has to be clean from debris, filth, rubbish, garbage, rodents, and vermin, safe fire emergency exits, etc. Then there's Health and Safety Code 17920.3, which says that any building or portion thereof, including any dwelling unit, guest room, or suite rooms, or the premises on which the same is located, in which there exists any of the following listed conditions to an extent that endangers the life, limb, health, property, safety, or welfare of the public or the occupants thereof, shall be deemed and hereby is declared to be a substandard building. And so again, it lists off a bunch of different conditions which would declare this property to be substandard. So lack of hot and cold running water, improper kitchen sink, lack of adequate heating, dampness of habitable rooms, visible mold growth, general dilapidation, right? The code goes on for quite a while, but it's very long. It's too large to include in this slideshow, but you can always look it up. Health and Safety Code, California Health and Safety Code 17920.3. Okay, so we're talking about the landlord's responsibilities. Now let's talk a little bit about the tenant. So a tenant must take reasonable care of the rented property and common areas, such as hallways. This means that the tenant must keep those areas in good condition. A tenant must also repair all damage that he or she causes or that is caused by the tenant's guests, children, or pets. California Civil Code Section 1941.2 requires the tenant do all of the following. Keep the premises as clean and sanitary as the condition of the premises permits. Use and operate gas, electrical, and plumbing fixtures properly. Examples of improper use include overloading electrical outlets, flushing large foreign objects down the toilet, and allowing any gas, electrical, or plumbing fixture to become filthy. Dispose of trash and garbage in a clean and sanitary manner. Not destroy, damage, or deface the property to the premises or allow anyone else to do so. Not remove any part of the structure, dwelling unit, facilities, equipment, or appurtenances, or allow anyone else to do so. Use the premises as a place to live and use the rooms for their proper purposes. For example, the bedroom must be used as a bedroom and not as a kitchen. And finally, notify the landlord when deadbolt locks and window locks or security devices do not operate properly. And I'll even say that I think that notification of the landlord includes just any issues that are perceived, right? They have to tell the landlord if there are problems with the unit. Otherwise, the landlord cannot, fix it. And also the tenant could actually thereafter may be responsible because they just let it happen. They didn't tell anybody. So that notification one at the end is super important. And I think it applies to just every issue. All right, the next is Civil Code 1950.5, which is essentially the California security deposit law. So first of all, the definition of a security deposit is any payment, fee, deposit, or charge imposed at the beginning of the tenancy as an advance payment of rent or to be used for recovering rent defaults, repairing damages caused by a tenant, or cleaning. This does not include an application or screening fee. The first month's rent isn't considered a security deposit, but money paid in excess of the first month's rent, including what is called the last month's rent, is considered part of the deposit. So for example, if the landlord asks for first month, a security deposit, and a last month as part of the application for the rental unit, the last two together are actually the security deposit. So how much can a landlord collect for a security deposit? A security deposit may not exceed 2 times the monthly rent for an unfurnished unit or 3 times the monthly rent for a furnished unit. What can a landlord deduct from the security deposit? A landlord may deduct from a tenant's security deposit only the amount that is reasonably necessary to 1, cover rent default, 2, repair damages a tenant or a tenant's guest cause other than normal wear and tear, 3, do necessary cleaning defined as the amount of cleaning needed to return the unit to the same level of cleanliness as the beginning of the tenancy, and 4, if allowed by the lease, cover the cost of restoring or replacing personal property, including keys or furniture, excluding ordinary wear and tear. And if you're asking what is wear and tear, there is no definition. All I can say is that what I've seen in my experience is that that definition expands commensurate with the length of the tenancy. So the definition of wear and tear for let's say a 1-year tenancy is very narrow, as opposed to a 30-year tenancy. The definition of wear and tear is more expansive. Landlords are obligated to offer a walkthrough inspection at the end of the tenancy. Tenants have a right to a walkthrough inspection no earlier than 2 weeks prior to the tenant vacating. The landlord must give 48 hours prior written notice of the inspection, unless the tenant waives this requirement in writing. The purpose of the inspection is to identify needed cleaning for the tenant to perform before moving out, so as to avoid deduction from the security deposit. Immediately after the inspection, the landlord must provide an itemized list of repairs and cleaning that need to be done to avoid authorized deduction. The landlord may still deduct for cleaning or repairs that were not identified during the inspection because they were concealed by the tenant's belongings. So this is a continuation of the security deposit law. When does the security deposit have to be returned to the tenant? within the deposit, and 2, return any remaining portion of the deposit to the tenant. Where several roommates live together and have paid a deposit, the landlord is not required to return deposit until the unit is returned to the landlord vacant. The requirement to provide an itemized statement of landlord's charges along with receipt. If more than $125 is deducted from the deposit for cleaning and repairs together, the landlord must attach to the itemized statement copies of documents showing the landlord's charges and costs to clean and repair the unit. The effect of a sale on the deposit. A landlord who sells a rental property must either 1, transfer the deposit to the new landlord, or 2, return the deposit to the tenant, but they cannot keep that money. The tenant's recourse if a deposit is not returned within 21 days of vacating. A tenant who does not receive the refund and accounting within 21 days or disputes the amount claimed by the landlord may sue the landlord for the disputed amount in small claims court if the amount is less than $10,000, and up to twice the amount of deposit for the quote bad faith retention of, which is the unreasonable refusal to return any security. In court, the landlord has to prove that the amounts retained were reasonable. Okay, so this is Civil Code 1954, which discusses lawful landlord entry. Landlords may only enter to make necessary or agreed repairs, decorations, alterations, or improvements, supply necessary or agreed services, or exhibit the dwelling unit to prospective or actual purchasers, mortgagees, tenants, workers, or contractors, or to make an inspection pursuant to Section Civil Code 1950.5. Landlords must give the tenant written notice to enter at least 24 hours prior to the entry. A landlord does not need to provide written or verbal notice to enter in cases of emergency, such as a fire or flooding. But in that case, they would have to leave it after they came in. The tenant cannot demand that they be there when the landlord enters, but they can be there when they enter. They just can't say, well, you can only enter when I'm there. Entry must be during quote unquote normal business hours, which is usually assumed 9 to 5. Landlords must state the time and date as well as the purpose of the entry in the written notice. And in Richmond, this is important because it is a just cause to evict a tenant who denies a landlord lawful entry after the tenant has been warned to cease denying lawful access and then continues to do so. Civil Code 1946.1. This is proper notice when terminating a tenancy. For no-fault evictions, a landlord must give at least 30 days written notice to terminate a tenancy if the tenancy is less than 1 year. Under the same code, a tenant must give a 30-day written notice to vacate and can give notice on any day of the month once the lease is converted to a month-to-month lease. A landlord can require more than 30 days notice if the tenant is on a fixed-term lease when they are giving notice to vacate. But it really can't be too much more. I think 30 or 60 days is probably the max. Under Civil Code 1946.1, a landlord must give at least 60 days written notice to terminate a tenancy if the tenancy has lasted a year or more. And note, any termination notice served in the city of Richmond must cite one of the permitted just causes for eviction unless the rental unit is fully exempt from the rent ordinance. Civil Code 827. So this is giving proper notice for changes in the terms of a tenancy, which includes rent increases. Generally, changes in terms of tenancy require a minimum 30-day written notice. A notice to increase the rent by 10% during any 12-month period or less requires a 30-day written notice of rent increase. A notice to increase the rent by more than 10% during any 12-month period requires a 90, that's 90, written notice of rent increase. This requirement became effective January 1st, 2020. Before that date, it was actually only 60 days. Civil Code 1951.2, which is known as the lease breaking law. So if a tenant breaks a lease, they may be liable for unpaid rent remaining on the lease, but only if, first, the landlord attempts to mitigate the unpaid rent damages by making a reasonable effort to re-rent the unit, and the unit remains without a sitting tenant. In other words, if a tenant breaks the lease, the landlord cannot make the tenant pay for the remaining unpaid rent unless the landlord can show that they made a reasonable effort to re-rent and were still unable to find a replacement or new tenant. And finally, once a new tenant occupies the unit, the previous tenant's liability for rent is over. There is a law which prohibits landlords from charging two separate tenants for the same unit. And finally, just a small note that landlords are also capable of breaking a lease. Remember that a lease agreement is a contract, and both parties to that contract have obligations that they have to fulfill. For example, on the landlord side, it's that implied warranty of habitability or the implied covenant of quiet enjoyment, which we discussed earlier in this presentation. Thank you so much. We truly appreciate anybody who has participated and viewed this workshop. You can always contact us, contact the Richmond Rent program at 510-234-RENT or 7368. You can email us, that's rent@ci.richmond.ca.us, or you can visit us at www.richmondrent.org to set up or request an appointment. On behalf of the Richmond Rent program, thank you.